And before we begin, I just want to say thank you to the Jordan Center, the Jordan Center for the Advanced Study of Russia, which sponsored this program. And I particularly want to say thank you to the director, who's not here right now, Yanni Katsonis, but he will show up shortly for his enthusiastic reception of this idea. And particularly to Fiona Neil-May, who is our general secretary, what can I say, in the Russian sense of the term. The one responsible for all. So thank you, Fiona. So today's topic, Russia's legal trajectories, may seem to have a foregone conclusion. I mean, isn't law a dead end in Russia? Did Russia ever have a legal system? Wasn't Russia an autocracy and then a communist regime? And then isn't rule of law incompatible with these kinds of government? Or, as I put it on our flyer, isn't Russian law an oxymoron? Well, obscured by the everyday critiques of Russia's rulers is the reality that for centuries, law has been part of Russia's way of governing and part of Russian society. Also obscured is the intense interest in Russian law that has developed among historians of Russia, both inside Russia and outside, especially in the last 2 decades. So today's panel is designed to give you a taste of that new history, that new legal history of Russia. So in particular, we want to welcome a Russian specialist in this field, and that is the Jordan Center's visiting fellow this month, and that's Tatiana Borisova, who is from the Higher School of Economics in St. Petersburg. And Tatiana's visit is what gave us the opportunity to put together this condensed, but I hope, informative and provocative panel. So I'm going to make no more comments at this moment. We're going to go straight to work. The order of the presentations, however, is not the same as on the flyer. We're going to begin with 2 papers on legal process to look at how the legal system worked for ordinary people in one case in the 19th century, before the legal reforms. And then we're going to take a second glimpse at the law in action in the early Soviet period. And those papers on law in action are given by Sergei Antonov and Retish. And then we're going to move to an overview on and an interpretation, I would say, of the Russian legal system and its traditions by Tatiana Borisova. And then finally to a paper by Cathy Frierson on how a particular law works, has been changed, and its significance after 1991. So law in the context of the Russian Federation today. So you have to stay to the end to see how it all turns out. So after those presentations, and they're going to be relatively short, 15 to 20 minutes, and then we'll have a short break for coffee. Then we'll have comments by our 2 guest speakers, Daniel Holzebach and Richard Boardman. And then we'll conclude with a general discussion open to all the panelists and all the audience. So I'm going to introduce each speaker very briefly before that presentation. And so we'll begin. And we're going to begin with Sergei Antonov, who is an affiliated scholar at the History Department of Queens College, CUNY. Sergei has a PhD from Columbia and a JD from NYU School of Law. He's working on a book on legal culture and legal practice in the 19th century, seen from the perspective of personal credit. Sergei.
Thank you so much, Jane, for the introduction, and also thanks to Yanni and Fiona for organizing this, and for my colleagues for their wonderful, interesting papers. Well, this presentation is basically a chapter from my book that I just turned in, which is a history of personal credit in Imperial Russia. So basically, when I a couple of words about the project overall, I was simply looking for an area of legal practice that would kind of allow me sort of the broadest possible perspective, and I clearly discovered, or very quickly discovered, that basically on the one hand, debt was and credit bankruptcy was basically bread and butter of 19th century legal practice, kind of much as almost as much as it is today. Basically, in most legal matters that involve most private law matters that involve property disputes, contracts, inheritance, even some issues that we would call family law today, like for example disputes between husbands and wives, involved debts to some extent. And also debt was involved in many criminal law issues, which is kind of surprising, but it just sort of happened very often that a simple civil law dispute turned into a forgery or fraud investigation, and sort of a simple bankruptcy could land the bankrupt in a criminal trial. And so conversely, sort of on the one hand, debt was bread and butter of legal practice, but conversely, law was absolutely crucial if we want to understand just how this culture of money, sort of economic culture in Imperial Russia, was operating right there on the threshold of this sort of big capitalist transformation of the late 19th century. And sort of, again, I quickly discovered that even though borrowing and lending sort of very heavily dependent on informal personal connections and reputation, but it was equally dependent on legal forms and legal practices in all kinds of ways. And so in terms of the chronological framework, I concentrate on the mid-19th century, sort of just before the great reforms of the 1860s, and sort of right afterwards as well. And some sort of really important changes, as far as my subject matter goes, were happening at the same time. So even though substantive law was pretty much left intact by the reforms, sort of there was a lot of liberalization of the kinds of debt documents you could issue. Different kinds of debt documents, but also debt imprisonment was abolished, sort of gradually restricted and abolished in 1879, and so were restrictions on interest rates, also in 1879. But then other changes that I noticed, and I think you can only notice this by reading actual court cases, is that more, I guess, nebulous changes in just sort of people's attitude, like the police, for example, were suddenly much better behaved once you get to like 1862, 63, 64. That was very clear. They were much less confident and less prone to abuses and violence. But on the other hand, those pre-reform courts that Cathy the Great originally established in 1775, they basically continued to kind of extend their kind of shadow over Russian legal practice for a very long time. I mean, in some parts of the empire, they were not closed down in 1866 and 67, but sort of continued on in some cases until the end of the century. And basically, those courts are typically seen as something like a legal dark age in Russian history. And if you're interested for more detail, you should look at John Liddon. I think his sort of book has this really sort of concise and informative overview. And I basically started up with the sort of same attitude when I went to the archives and started looking at actual court cases. I was expecting to find that there would be these pre-reform cases that were horrible, unfair, and convoluted, and so on and so forth. And then suddenly we get a reform, and debt and credit suddenly work much better. And I was actually kind of surprised because when I started reading those cases, they didn't know procedures and sort of the court setup before the great reforms. None of that looked perfect. Some of it looked definitely funny. But what they did not look like was a dark age. It's kind of true that if I were looking at court transcripts from sort of a later period when most of that was done orally, I may not be able to catch some nuances or sort of complete story in some ways. But here, procedure was written, and so yes, you could have some behind-the-scene maneuverings. In fact, I'm pretty certain that a lot of that happened. But at least the bulk of the stuff was in writing, so that sort of made me somewhat more confident in what I was reading. And now, why does all this matter? I think it's sort of a question that you might be asking at this point. And I think Georg Borisova, in his massive study of the great reforms of the judicial reform, kind of explained what at stake very sort of quickly. Because if, as he argues, the Russians really were not ready to be, to have the rule of law, at least some elements of the rule of law dumped on them as the result of the reform, then if the reforms were basically imposed from above on a population that had no use for law or appreciation of law, then of course it's the reform itself is its lack of clear success basically is a lot easier to explain. So if we sort of buy into this sharp contrast between some sort of old European Western style legality and sort of the traditional Russian legality, then sort of becomes much easier to accept that when with everything that was created by the Great Reform was simply removed in 1917. And so I was sort of grappling with this whole question, and then I just basically started looking. I was looking at a lot of different things, but in this chapter, I just looked at some of the sort of most sharply criticized features of the old courts. First I looked at institutional autonomy, meaning administrative intervention, courts functioning. I looked at issues of corruption, bribery, but also lack or not lack of legal advice. I realized that basically, a lot of things that I've seen were, were confirming what pre-revolutionary lawyers and legal scholars, historians were writing. But also I discovered that those common criticisms sometimes turn out to be rather strange and inconsistent. Basically, sometimes those criticisms apply to basically sort of institutions other than the courts, like the police or sort of small claims law level courts. Or some writers thought that basically studying actual court cases was not even necessary because reading Gogol was enough. Or some other great Russian literature would teach you everything you need to know about Russian law. Then other writers would dump all those criticism on the reader, but then admit that high-level courts actually were operating in a much more efficient way. And then criticism was also inconsistent because pre-reform, this Russian legal dark age, pre-reform courts, at the same time are criticized for following the law too strictly at the expense of justice, or to be too concerned with justice at the expense of legal procedures and regularities. And so basically that's sort of the kind of question I'm here grappling with. And so I'm going to leave aside for a moment sort of the issues that are not in this chapter, like corruption, institutional autonomy, and I'm going to look at sort of the more technical questions. One question is this common criticism that the Russian court system before the reform was fragmented in line with Russia as a state system. And then I'm not going to give you too much detail on this, but the second criticism was that Russian courts employed so-called inquisitorial procedure, meaning giving too much power to judges and not enough power to individual litigants to present their cases. And finally, that Russian law before the reform used this outdated system of formal proofs that as a practical matter required a confession or two witnesses or ideally a document that should prove it. And basically what I discovered, I think I've gone for a couple of my time already, so just sort of a couple of sentences on each of them. Well, the estate-based justice was designed to, by Cathy the Great, to basically ensure that trials by one's peers. So nobles would try nobles, merchants would try merchants, and peasants would be tried by nobles as well. That was kind of an exception. And so the criticism is that justice, that made justice fractured and unreliable, as sort of one writer after another has noticed. And so I'm going to sort of leave aside the question of what's our ideal and what's our standard of comparison, and I'm just trying to show in this chapter that sort of the way the system was set up, it was just technically impossible, practically impossible for this kind of estate-based structure to operate. And there are sort of three short reasons for that. One being that lower tier courts, basically the ones that were estate-based, they basically didn't matter all that much in the Russian legal system because they were constantly overseen and sort of controlled by the high-level courts. And I guess the second reason is basically just many cases. I mean, I can't really give you a number, but basically I would say that more often than not, your court case would involve people, members of different estates. And especially, criminal cases tended to have dozens, not dozens, but would have a double-digit number of defendants. Because they would, the way Russian police work, they would grab everybody who's involved in any way. And definitely property disputes, more often than not, involve different estates. And in these cases, you just simply cannot have a fractured estate-based legal system. You have to sort of figure out a way to work it out. And basically joint sessions when those so-called estate courts would work together to resolve the case became the rule from pretty much from the very beginning. And so in other words, pre-reform justice was estate-based only in the sense that it was more or less administered by nobles who pretty much dominated the court system. Now the second quick thing is this whole idea of inquisitorial procedure that was supposed to be secretive and written and basically leaving no discretion to the litigants. And yes, I mean the procedure was kind of long, but so it is in U.S. federal courts today, as we all know. There's a giant background. But in 19th century Russia, the actual problem, as I discovered, was not so much that the system was too inquisitorial and didn't allow enough sort of private initiative, but the opposite, that the system really was not inquisitorial enough because it kind of allowed litigants, plaintiffs or defendants to basically too much control over sort of how they file those petitions and how many they would file and how often this exchange back and forth would continue. So in other words, the courts more or less just sort of sat back and allowed them to fight it out until both sides were ready to actually come to a judgment. And so finally, the sort of even probably better known is this whole system of formal proofs that's criticized, I think completely justly, that judges were not permitted to freely evaluate evidence or basically decide what was going to be admitted and what wasn't. In criminal matters, the key question was confession, right, which actually wasn't as easy to get as you would think, or two witnesses, which also wasn't quite as easy in every case. But in cases that I'm studying, for the most part, involving property and money, the key issue was written documents, because nobody was going to confess to anything if it's a property dispute. And the most important issue in that cases was whether the debtor actually signed the document, and whether that signature was the correct signature. And basically, it didn't really matter how formal these proofs were going to be. Somebody was going to have to make the judgment whether that signature was the right signature or whether that document was the kind of document it's supposed to be. And so in practice, here come the handwriting experts, which is, those of you who are US lawyers, you know that there was this big change that happened around the same time in the United States in evidence. Evidence basically from recognizing somebody's signature, like I recognize that this is Jane Burbank's signature, as opposed to just recognizing somebody's handwriting. So from just recognizing somebody's handwriting because I knew that person before, we're changing to actually analyzing the writing and saying, well, this signature corresponds to that signature. And so in America, at least, there were all these, so-called experts, usually art teachers, running all over the place, and it's still to this day kind of a questionable legal issue. And I discovered that similar thing was happening in Russia, that usually they would use some kind of trusted expert, usually a gymnasia teacher, and sometimes you would use, literally you would get together hundreds of clerks from courts at every one of those courts, because they were all in the same building, and so they would all say, well, that looks good, that looks good, and then they would take a poll, basically. And so, in other words, even though it's supposed to be a system of formal proofs, somebody still had to basically evaluate evidence, use technical personnel, and basically make a call, in other words. So, in other words, this kind of discretion and just wasn't, couldn't really possibly be removed from the system. And so, in conclusion, just why, again, to go back to this question, why is it important today? Well, I mean, when we talk about Russian law today, we typically sort of assume that there's this dichotomy between some Western-style rule of law, and on the other side, there's some kind of legal nihilism, right, that many people use, and it's primitive and archaic. And so my research basically suggests that even we sort of bracket out the rhetoric of the rule of law, much as we all respect it and like it. So if we bracket it out for the moment, there's still sort of old, centuries-old legal tradition that sort of as a practical matter, it's been there for a long time, and it's going to be there for a long time. So it doesn't quite matter what happens to Putin or Stalin or Lenin for that matter. So I guess it's sort of a long direct kind of argument that I'm making. So I think that's it. About 20 minutes. Okay. So thank you, everybody.
The next speaker is Retish, and Aaron is an associate professor in the Department of History at Wayne State University. He has this book called Russian Peasants in Revolution and Civil War, Citizenship, Identity and the Creation of the Soviet State, 1914 to 22. This is now available for all of you in paperback from Cambridge University Press.
Please buy it.
But his presentation today is based on work he's doing for a new monograph. And this is about courts and legal culture in the countryside, the Soviet countryside, from 1917 to 1939.
Thank you very much. So this is very much law in practice, and I'm going to make broad strokes from essentially 1917 to 1928, 29, basically going from how we moved from these guys, who hopefully some of you recognize as lowest court judges in Moscow province, to people's court judges of the Soviet era. So to start off, having this theoretical break from the past, the leaders of the Soviet state decreed in November of 1917 the abolishment of Russia's existing court system. And they replaced it with quote-unquote proletarian courts. They also tossed out the existing civil and criminal law codes in favor of ruling by quote-unquote proletarian consciousness. These brash declarations left peasants and judges in the countryside in a quandary, wondering where and how to resolve legal disputes. They had, over the last 50 years, integrated the volist, the township courts, into their lives. Peasants sought out the volist courts to mediate disputes within the village and hut that customary law would not or could not resolve. So this paper is going to focus on the development of the local people's courts, the Narodnaya Sudi, which inherited more or less the role of volist courts as the courts of first review in the countryside. And I'm going to look at the first 10 years of Soviet rule. I'm going to make three very broad points. First, that the new Soviet court system did not represent a radical break from the past. That is, there wasn't this revolution. Second, that peasants in the 1920s used the people's courts to resolve a range of family disputes and draw on state benefits. And then by way of conclusion, I'll argue that peasant legal culture continued in a modified form from the late imperial era to at least 1928. And this is drawing on research that I've done in Kirov, Vyatka, and I realize that most of my examples are actually from Vyatka in the northeast, Samara in the south, Nizhny kind of in the center, as well as Moscow and the Udmurt Republic. I've also done some research in Kazakhstan, which is not integrated into this. So I argue that peasants collectively turned to the people's courts with the expectation of justice for wrongs, in this way resembling the pre-revolutionary Volus court. I'm going to focus specifically on women as well, who played a dominant role turning to the courts. Okay, so part one. Despite the fanfare, despite the fanfare of abolishing the old system, the first Soviet decrees only partly discarded the old courts and existing civil and criminal codes. Soviet judges were continued to use the laws that did not contradict revolutionary consciousness to decide their cases, which more or less kept the legal code largely in place for the first 4 years of the Soviet era. The People's Commissariat of Justice, Narkom Yust, oversaw several court reforms in the first years of Bolshevik rule that quickly centralized and formalized the courts, moving away from this discourse of utopian popular justice and towards a drive to use the courts to build the revolutionary state's authority. So the courts at the end of 1918, at least at the local level, would seem very much the same as they had before the revolution to most people. I don't want to push this continuity too far. There was still, the courts were still agents of revolution, alongside the Narodные Sudi, alongside the people's courts, were also new revolutionary tribunals that prosecuted citizens for broadly defined counter-revolutionary crimes. A picture that I'll show you in a few minutes. Let me kind of give you a little bit more on this gradual transformation of the local courts. Narkom Yust encouraged this slow movement to a new court system when it invited the current staff from the imperial and the provisional governments to continue on. Most local and district clerks agreed to continue on and help the courts run its daily schedule. They are the only ones who knew court procedure. They knew how to keep records. They wrote out decisions. And most importantly, they knew how to collect fees. They were to help the new judges, who were supposed to be these true allies of the Soviet regime. And by and large, they did. In most places, they actually made this transition. There were some cases where that did not happen. In Tobolsk province, former judges simply continued in their positions, and in April 19, were still issuing rulings in the name of the provisional government, something that I also saw in Samara. And suspected sabotage from the former staff unhinged the new courts in Tver and Astrakhan. Almost all members of the early Soviet courts with judicial training or administrative experience had served in the courts under the czars. A typical picture of the newly selected People's Court is seen in Perm province. In 1918, the court included an official who had served as secretary for 40 years in the local czarist administration, a secretary of the local zemstva, and 3 former justices of the peace. This is from the 1917 Justice of the Peace. In Orlov district in Vyatka province, a majority of People's Court judges had worked as in the Volus courts as scribes or as courtroom assistants. This is clearly seen in this picture. So this is from 1917. These are the judges of local courts in Vyatka district of Vyatka province. At the left, we do not know who that woman is. The person to her left became part of the court administration. The guy in the cane, Nikolai Popov, was a judge, was a Volus judge, and then he became essentially the deputy of the judicial organ of the province through the Civil War, and then in the early 1920s was demoted essentially to be part of the district court administration until 1926. In the second row, all of them were essentially they all made the transition to People's Court judges. All of them except for this guy right here, who was secretary in the pre-revolutionary time, and he became secretary at the provincial level of the court system. I will come back to these guys in just a minute. Well, actually, so this is the Third Congress of People's Court Judges in 1921. And you see the transition. There's actually, I think, I don't have the names, I couldn't find the names of anyone, but the guy in the middle with the beard, I think is the same one as the second to the right, just a little older with a little bit scraggier of a beard, as I would be as well in 1921. So you see this transition from the older guard to the newer guard. There are 5 returning soldiers who are now People's Court judges. So in 1922, a new court system was set in place that lasted through the next era. Narkomuse finally drafted civil and criminal codes, and it also began to professionalize, or if you will, Sovietize the courts. They put new officials in the local courts by 1923, who were either more educated or had closer ties to the Soviet cause. By law, People's Court judges had to either be experienced political activists or have judicial training. And that's what you see here in this picture. Many judges and secretaries came to their position because they were literate and had some experience in the court system. Many of the secretaries were often demobilized Red Army soldiers who had already served as secretaries in the military or who had worked for the local party cell. Hidden in the statistics, though, and you can find kind of their past, but if you read their autobiographies, what I found is that a lot of these secretaries had religious training. Many of them were children of the clergy, or actually had become, or gone into, and who actually had religious training, including stints in the seminary. Skills in writing and basic interpretation of text presumably helped them get jobs in the courts. But their experiences also drove them to the Soviet courts. One example is Valentin Antonov, who grew up in Uransk, in Uransk district in Vyatka. He escaped the village through singing and joined the church choir in the city of Vyatka. There, during the revolution, he sided with the workers and then joined the Red Army, joined the legal bureau after that, and then actually became a judge. The other path is from Ivan Morozov, who was a long-serving People's Court judge in another district of Vyatka. He had been born in a small village in the district. After the revolution, he worked as an agitator for the Soviet state and then joined the party. In April 1923, he became a judge in one of the districts, but he had no legal training. He studied some law on his own, but at first, by his own admission, had to rely heavily on the secretary, who actually knew how to run the court. According to his own account, what mattered most in his appointment as judge was that he was a member of the party and willing to agitate among the population. Okay, let me make sure that I want to spend enough time to talk about what the courts actually did in the 1920s. The court system was meant to bring, and actually, so this is actually a picture from the Revolutionary Tribunal. So you have this open air court. And then I like this with the contrast of, this is a People's Court session in the late 1920s, held outside the court. I'm hoping this will be the cover of my book, so when you see it.
Close the fluorescent light so we can see better. Just
yes, there you go. So this is, I think, kind of a special session of the court. Yeah. The courts were an important tool of the Soviet state in building an accepted value system and establishing a relationship with the population. Did the populace come to use and accept the Soviet courts? Or, asked another way, did Russian legal consciousness that was emerging before 1917 develop through the 1920s? As I'm going to argue, clearly it did. The People's Courts heard an astounding number of suits, considering several organizational difficulties. They first had to wade through holdover cases from the imperial era, and then in 1919 began to actually hear cases from the present day. In the 1920s, they heard more and more cases. So in Nizhegorod, People's Courts heard over 48,000 civil cases in 1926, and over almost 54,000 cases in 1927. 1928 saw an even greater rise from 1927. So actually one of the problems was that the courts were getting clogged. What did the peasants want from the people's courts? In essence, peasants relied on the court for justice and to guarantee new benefits promised by the Soviet state. Peasants especially relied on the courts to resolve disputes within the home, including divorcing their spouses and solidifying claims to land and resources. This is certainly not all. Cases range from the bureaucratic, like adoption, declaration of the death of a spouse, permission to build structures, etc., to suits of damages for potrava, damage from trampling of crops. Soviet officials' categorization of cases is very vague, and it's very hard to get a good sense of how many cases fit into which category. And there are also shifts, which I can talk about during the Q&A. But three, or kind of 3.5 cases kind of dominated the docket: divorce, alimony, and property disputes. Peasant petitions for divorce flooded the courts to take advantage of the December 1917 Family Law Code. This issue far outnumbers any other civil matters. The peasants rushed to end their unhappy marriages. In Imperial Russia, divorces went through restrictive and expensive ecclesiastical courts, and traditional cultural mores made divorce nearly unheard of. Applicants did not need to supply a reason for divorce, but some did. Kirill Sterkov, for example, asked for a divorce from his wife in December 1919 because he was seeking a fresh start, away from the church-based marriage to a woman with a different disposition from himself. He'd also left her 6 months earlier. In other cases, spouses had disappeared during the Civil War, either by mobilization or through work. Peasant women especially petitioned the court for divorce. Opportunities for divorce were new, but the issues for most female litigants remained unchanged from the imperial era. They turned to the courts to free themselves from abusive and personally unfulfilling unions. Anastasia Trubinskina petitioned the court for a divorce from her husband Ivan. At the center of her claim was a dispute over property as well as abuse. Anastasia wrote that she and her husband fought constantly. During the summer field work, she went mushroom hunting in the forest. When she returned home, her in-laws and her husband cursed her for leaving during such an important time. They beat her and kicked her out of the house. Anastasia petitioned for divorce and the return of money and property that she left in the hut. The court refused Anastasia's request for the return of the property, but they did grant the divorce. This is, I think we have two of the experts, of course. These should be sound very familiar. This is the continuation of the Volos court's tradition of where daughters-in-law bring abuse from within their adopted household to court. Peasant women also sought alimony after divorce and for their even out of wedlock as well. That meant establishing paternity, a tricky problem in the 1920s countryside. Two suits reveal how the court handled this case. In 1925, Alexandra Bernakova brought suit against Fyodor Zlobin, claiming his paternity of her 10-month-old baby, and demanded that he pay alimony of 5 rubles a month. The court heard testimony, including a doctor from the women's hospital, who claimed that the baby's hair and facial features did not match Zlobin. Nonetheless, the court supported her claim. The following year, Yana Porikhina filed a statement claiming that Semyon Noskov fathered her child. Noskov was a miller and already married with children. Porikhina was an unmarried, illiterate, and poor 18-year-old. She claimed that they had a secret relationship. Porikhina's witnesses stated seeing the two of them together 9 months before the baby was born, and the court again found in her favor and forced him to pay alimony because he couldn't prove witnesses beyond his family members. 2 points are clearly made in these cases. The fact that peasant women, one who was clearly poor, took on male peasants in the court shows that they believed that they could win suits in the Soviet courts. The support that mothers won probably could not save them from a miserable life. Alimony was just not that great. Alimony suits then served as opportunities for women to defend their honor in a public space that was not controlled by still a patriarchal village administration, with their neighbors as witnesses. Very quickly, peasants also frequently turned to the courts to resolve family disputes over divisions, FDLs, and inheritance, a lingering problem from years of war. Courts based their decisions on the new Soviet law, limiting inheritance, but also included the need to minimize economic inequality. For example, in Kostroma province, Stepan Petrov sued his brother because they could not agree over the division of remaining inheritance of their brother, their deceased brother. The court found that the agreement was in violation of the decree to abolish inheritance, and furthermore, Alexander owned 2 homes and had no further need for movable property. So it, kind of going beyond its jurisdiction, decided just to seize the remaining property. Once again, women used the courts to fight for newly found rights, including claims to household property. In 1927, Tatiana Morkotova asserted her rights as a fully equal member of the household when she filed suit against her former father-in-law to reclaim, quote, what is rightly mine, after she left his home when divorcing her husband. The court did an inventory of the household and followed the law that gave women equal ownership within the household. It granted ownership of essentially her movable property, as well as 38 rubles and 50 kopecks. Okay, there's another section about the court also kind of serving as a mediator to reduce the financial and social trauma after the famine. This was filled the dockets in 1922, 23, 24 in the lower Volga. Actually, there are a whole diala of famine disputes, property disputes, people taking advantage of other people based on the famine. But I will, and the courts usually ruled in the victim's favor. Okay, let me just move on to the conclusions. Did peasants turn to the people's courts to resolve their conflicts, and did they expect due process when they did? The answer is clearly yes. Peasants, especially female peasants, looked to the courts to improve their domestic lives and to ensure benefits guaranteed to them by the new regime. People's courts consciously worked to undermine the rural patriarchal order. Did peasant legal culture from the late imperial period continue into the net era? The answer is a qualified yes. Peasants voluntarily used legal opportunities, be it in family law, property, or state aid. They also learned laws and what legal opportunities worked. There was certainly overlap between how peasants used the volus and the people's courts. Property and commercial disputes were frequent in both courts, and show peasants' willingness to rely on the courts to resolve business and household conflicts. Soviet organs of justice did have different goals than the imperial ones. The centrality of transformative Soviet family law in people's courts, notably divorce and alimony cases, set the people's courts apart from the imperial era courts. Finally, Soviet people's courts and Soviet law might not have been revolutionary, but they did promote the rural poor over the well-to-do, something that became explicit with the Stalinist term. I'll leave it with that, and with this is, so you went from a volus court, so this is a people's court in the late 1920s with Lenin and Marx there above. But you also see the poor conditions of the court in practice. I'll leave it with that.
So now we're going to turn to a different mode or level of interpretation of the law. And the speaker is Tatiana Borisova. She is an associate professor at the Higher School of Economics, St. Petersburg branch. She received her PhD in history from the Institute of History, Academy of Sciences, St. Petersburg. And she's finishing right now a second PhD at the law school in Leiden, in the Netherlands. Her research focuses on codification in the Russian legal tradition, which she'll be talking about today. But she's also working on a new project, which is on the history, the legal history of private firearms possession in Russia from 1800 to 1930. Tatiana.
Thank you. I'm happy to be here. And what I'm going to present is different to the previous presentations in the sense that that is on official understanding of legality in Russia, so to say. It's a top-down perspective why there should be legality in Russia. It's official concept provided by elites in the long 19th century in Russia. I consider it from the beginning of 19th century till 1980. And I see it as this Russian official legality tradition as legality with adjectives. Because, and I just follow the term democracy with adjectives. This is the term used these days for Russia, for our суверенная демократия. So, and it's a funny, yeah, it's a bit interesting how it goes together. It's the same thing for legality. We used to have imperial legality, autocratic legality, самодержавная законность. Then we moved to revolutionary legality. That was 1970. That transformed to социалистическая законность, socialist legality. And now, any suggestions what kind of legality we have now? Суверенная законность. This is a term because we are so special, and this is our Russian legal tradition of adjectives. So I was interested in these adjectives. What are they about, so to say? What makes us so different? Why it is always articulated? And the main point I'm going to present here today is that the main difference is that legality is a point of is about order in Russia. Somehow, in official interpretation of legality, justice is a missing concept. It's not there. But order, it should be brought. So whenever it should be brought by legality is there. So whenever there is a public talk about legality, it's about fostering the order, fostering the law. So my question was why Russian law has always been to be fostered by the Russian authorities. Why is that? And so these are results of my PhD in legal studies, and I consider the Russian legality tradition as a condition for rule of law in Russia these days. Because since 1996, Russia has been a member of Council of Europe. That means that Russia complies to the standards of Council of Europe in relation to rule of law. And there is a discourse of rule of law in Russia, but its understanding, its conceptualization is really legality-based, so to say. So, and in general, traditions do matter. So it's not only the Russian issue, so to say, this legal tradition being so important. Legal historians and legal practitioners as well witness this coming back of traditions these days as a reaction of globalization. But in Russia, again, it's getting to a kind of extreme, and we do have Russian national tradition as an argument in the reasoning of constitutional court these days. And we could probably guess at what kind of cases. At the cases, within the cases when non-discriminatory principle is violated and human rights in general violated in relation to LGBT communities, adjectives, and new legislation proceeded against them all over the Russia. And the reasoning of the Constitutional Court is based on the Russian national tradition. So tradition is getting very strong here. That's why it's so important to study. My main thesis in the dissertation is that in the Russian case, we see the problems, the problematic in general, institutionalization of Russian law. What I mean by institutionalization of Russian law? I relied on basic institutionalist theory of Bergman and Luhmann, that's a classical social theory of institutes, and classical legal scholarship of Western legal tradition by Harold Berman. Berman traced the development of authority of law in the West, so I used him as a model in order to examine why authority of law did not succeed in Russia. And just to give you an example how topical this issue is, the problem of authority of law, which somehow has not developed. I will tell you a story that happened to me not long time ago. That was 2010 at residential school in St. Petersburg State University. And you know what is residential school. That is a law department. They call themselves residential school in the state. So I was visiting the colleague, the office, that was the office of civil law department. And, well, the colleague is writing legal history as well, so we had things to discuss. That was very in our talk. And he mentioned to me, by the way, that there was a chair of President Medvedev, Dmitry Anatolievich chair. And I totally messed up the situation. I was introduced to the chair. And I didn't get it. I was just trying to sit in it. That was my last time at this department. I was never allowed to be in here. My colleague was scared. I was doing something totally irrelevant. I had to somehow greet the chair. I had to pay whatever I could to the chair, but never ever sit on it. And that is an interesting thing because the contrast is important. That's the contrast of place. The place should have been the fortress of institutionalization of law, so to say. That is the fortress of law as an institute. St. Petersburg State University Law School has been traditionally one of the most prestigious in the country. So it's about the Russian law to make presidents, not the chairs they sit on. So that's really interesting that it was my colleague who was totally scared and wanted me to get out and to go to the cafeteria and just to stop this embarrassment. He is a doctor of laws. But for him, it's kind of magic about this chair. It's not about the institutions that make Russian law. So that was something that I was so interested in, why Russian legal profession is so weak. Why do they greet the chair? Why don't they do the work to struggle with those chairs? So what I studied, and the main object of my research were legal techniques which produce sources of Russian law. I saw the sources of Russian law as a material embodiments of legality, so to say. Because my point, my idea and general approach is that in the sources of law, in the way how they're distributed around the country, in the way how they are accessible to ordinary people, to lay people, and to legal professionals, we see a certain algorithm, so to say, and roles of the users of law and the legislators. So we see how it should work, so to say, how it should function, and how it is seen by the authorities in Russia. So I consider two the most important sources of Russian law: the Digest of Laws of the Russian Empire, that was started 1835 and continued till 1918, and the collection of the legislation, which was started 1863. So I consider it very clear why they were needed, and they were initiated again with this rhetoric of fostering legality in Russia, and how they function, so to say. And in these sources, my idea was to see the understanding of legality by elites, and I would insist that this is important because elites provided the main discourse of legality. They do the lawmaking, and they do the general framework of how law functions in Russia and what form it functions in Russia. And in these sources of law, I see this embodiment, material embodiment of features, of these specific adjectives of Russian law. And they are two mainly. The first one is extremely instrumentalist and formalist approach, very positivist attitude to law. That's the first one. And the second one is underlying the difference of Russian legality, the difference coming from traditions of Russian people, and the difference making Russian law and legality incomparable to the universalist legality, so to say. And it's funny indeed that Russian legal specialists do not find anything wrong with the joke, and I heard it in different legal conferences on human rights issue. When there is a discourse on human rights, you probably know the joke, they ask, права человека какого человека? Well, even if you think this, you never speak this up among your colleagues. How would we better translate it? Какого человека?
Which human? Which human?
Which exact human?
Rights of man, which man?
Yeah. That means that we do not have it. We have our tradition, and tradition implies hierarchy, for example. Yeah. So we just follow it, and we just follow the tradition. And the tradition, I see it in the sources of law, and in the way the Russian sources of law organize legal mentality, legal mindset, so to say. So I will concentrate on the digest because we are short of time. So the digest, the main credo of it was exactly to fix the Russian tradition. As Nicholas II stressed in the State Council, making no new laws, but bringing order to the old ones. So contrary to borrowed constitutional ideas, and they were in the air after the Decembrists' rebellion in 1825, the digest was presented as compendium of original national Russian laws, which had been practiced by Russian authorities and people for centuries. And the clear idea of the digest was to legitimize Nicholas' power after the uprising, that's for sure. And the tradition that digest had to fix and reproduce was underlined in Karamzin words written in 1811, exactly on the codification project, that the digest has to to underline the premise of the monarch's supreme legitimacy, to preserve, I quote here, at any price, the right to grant general benevolence from above. And the quote continues, the monarch is the living law, merciful for the kind and castigating evildoers. The love of the former, the kind, is obtained by the fear of the later. If people aren't afraid of the tsar, they aren't afraid of the law. That's the basic concept. So this is the very idea of conceptualization of legality. If law is more important, then the main stress is on enforcement, and enforcement is based on power. And if power is concentrated politically within autocracy and bureaucracy, then what kind of justice is in here? It's just about power distribution. So institutionalization is really jeopardized by this concept of power, and it's one source which is not Russian people, but Russian Tsar. So as envisioned by the monarch, the digest was a product of the complete systematization of law at that moment. And its articles would provide an organized compendium of current Russian law. There were 15 volumes, thousands of articles, within which an administrator or a judge would find a solution relevant to any particular situation. And in case of uncertainty, he would be obliged to address himself to the higher authority. So that's how Russian legality had to work within these many volumes of digest, and then its continuations and new editions. Everyone should have been possible to find a direct answer to a direct question. And it couldn't work from the very beginning. And you understand why? Because new legislation was come. And every piece of new legislation had to be, again, included in the digest. So the very idea of the digest to bring in legal certainty was hardly achievable. So it was a really illusion, but it was the illusion of legality, a very positivistic understanding of legality, of one particular book where everyone could find the right law. So it's important to see here very paternalistic attitude of the state, of the legislator. It was based on an assumption that Russian legal professionals were not in a position to interpret new legislation. Thus, special state officials were to define the changes which every new law made to the existing legislation. These changes were indicated in the most recent editions of the digest, or its most recent continuations. So these continuations came, they were thought to come every year. It was impossible to make these continuations every year, so they made them in different periods of time. But the most important thing here is that the digest had a priority over original legislation. So the legislator agreed that these bureaucrats have a higher power over the tsar, over the tsar's ministers, to interpret the legal meaning of every new piece of legislation. Why would that's a very interesting thing. That's a very interesting issue in general. Why legislator trusted some bureaucrats to find the right place and find the right interpretation of legal message of every new norm. And the answer lies in the very essence of the politics of modernization, of big steps of modernization, the big steps forwards, down steps back. So I would say that from what I read, and I read not only these legal sources, but also legal literature, legal journals, diaries, the general feeling is that they were not sure that the new laws are going to work, as Sergei mentioned that they wanted to have an original law, and they wanted to have a codified version as a possibility for discretion for local administration. So it was for the local administration to decide, should this new law work in its original form, or we take the digest form, or we just use the previous law. And that's very typical for the Russian legal tradition, so to say. And again, there is an issue of responsibility. Very often ministers proposing particular laws were not sure that the law would work as it has been envisioned. So they would put this responsibility on the codifiers to put it on the right place. And then it was, again, the question of being irresponsible for legislative politics and leaving this to some other administrators who misinterpreted the message, who just messed up the new legislation and lost the whole legal message. So that was it. And so we see here this technical approach which provided a diversity and jeopardized legal certainty in general. Because legal certainty implies predictability of legal order, and that was never the case, even with the digest and its numerous continuations. And in general, the system of Russian legal sources, they just mirror the political structure where powers were not separated, where administrative and legal branches of power have never been separated, and drafters of the digest have to decide if a particular piece of legislation has a general meaning, general legal message, so it should be treated as a legislation, or it's an edict, or it's an ukaz, which doesn't have to be included in the digest. So again, the legislator, the elites, they just left it to bureaucrats to decide it technically somehow. And the very, for example, my second source, the very edition of that was called collection of legislation, собрание законения распоряжений правительства, was introduced to bring in this clear difference. It was written in the edict on this, which introduced the collection of legislation, that in this collection only laws will be published. So again, bureaucrats making this collection had to decide what is the real law and what is edict. It was not clear by the legislator, because whatever came from the tsar had to be seen as a law. But the meaning of it had to be decided by the dispatched bureaucrats. Is it important for all of the empire, particular regions, particular group? So again, it was a technical approach to political issues which could not be solved in Russia. So in result, we have what we have. Russian legal tradition have accommodated coexistence of both rule of law and illegal rule of administration. So somehow, within long 19th century Russia, these both rules, so to say, are a part of legal tradition. And these both rules embed each other at a certain conceptual and functional level. Their interrelatedness should be further studied as a part of the tradition of Russian legality, which significantly narrows Russian concept of the rule of law in Russia nowadays, equals, again, today is the same situation as Putin wrote it in 1811. В России незаконны, а люди важны. In Russia, it's not laws, but people who count. Thank you.
Thank you. Tatiana? Cathy, are you set up? Okay.
I'll see if I can.
It's only this one.
Fiona, can we turn off just the front light?
We cannot.
That's fine. No, the whole thing.
No, the whole thing, unfortunately.
Can you see?
That's fine.
Kathy, can you see?
Oh, can I see? Yes.
Okay. So, our final speaker today, and then remember we're going to have a little break and then commentaries. Our final presenter today is Cathy Frierson. Cathy is a professor of history at the University of New Hampshire, and she is the author or editor of 7 books on 19th and 20th century Russia and the Soviet Union. With relevance to this program, from 1999 to 2004, she directed a faculty exchange program with a law school at Vologda and in the Russian North. And that was an exchange program about legal pedagogy. Her most recent publication is an anthology of interviews of orphans of Soviet political repression. And the title of this new book is Silence Was Salvation, Child Survivors of Stalin's Terror in World War II in the Soviet Union. And it's due out this month from Yale. Cathy.
Thank you. Being the last is really difficult to discipline myself because so many wonderful things have come up. But I think I'll go back to my paper and let our commentators draw all the threads together. I do think it's important to add how I came to the topic. I think that the moment of my coming to the topic of studying this 1991 law is very much part of the question we have here. What are the trajectories, or what is the trajectory? And I would say that when I first came to the topic in 2005, we were hitting the crest of, one might say, the most optimistic moment on the potential for the rule of law, and it's been on the decline ever since. So I thought I was doing an optimistic topic when I took this on, and it has ended most recently this week, rather sad. So let me just set the scene. In April and May of 2005, I was going to Russia to interview the so-called children of the Gulag, people whose parents had been arrested or often exiled or executed. And I found myself in the medieval town of Staritsa, which is between Moscow and St. Petersburg, at a gathering where my colleague Semyon Vilinsky had put together a group of 5 local orphans of political repression who were willing to be interviewed by me for my project. And that's why I thought they were there. It turned out, when we gathered at the house, that the first part of the meeting with Semyon, who had come down from Moscow, was that they wanted to discuss this recent law that had been issued in August 2004, monetizing welfare benefits across the board from the Soviet era into the Russian era, and including the benefits that they, as children of repression, had been receiving through this 1991 law. And here I had come in, this was only my second interview with this cohort of people. I expected to come in and be talking to victims and people who were suffering from trauma, and I had all of this training on how to be gentle with people who were traumatized and so forth. And instead what I saw was a seminar on this new law that had come out in August of 2004, and they were just hopping mad. They all knew it down to the last article, and they had come together to begin to develop a strategy to challenge the reform of 2004 that was reducing the benefits. that they had received through the law of 1991. So having long been interested in the question of legal consciousness, I said, oh my goodness, this is a cohort of people I least expected to be going to the barricades to defend their rights by using the law. They do have PTSD, they are traumatized, they are elderly, and yet they knew the law and they were determined to use it for their interest. So I thought I would pursue this project to try to determine whether this law of 1991 had contributed to the expansion of legal consciousness, rights consciousness, and more grandly, although we try not to use that term anymore, the rule of law. So at this point, 9 years later, I have come to understand that of the two major aspects of the law, one being the historical reckoning that it embodies with the abuses of the Soviet past, and the other being a social welfare benefit package, a social welfare law. As of when I sent this paper in 3 weeks ago, I was still thinking the historical reckoning was the more positive and enduring accomplishment of the law. If indeed Memorial is shut down, then the story goes the other way. So that's where we are. So I will now just turn to reading the paper. So for those of you who don't recall these years, let's see if we can get that. This is right. Nope. Should be next. Where's Fiona? I'm hitting the, oh, there we go. Okay. So you'll note that the title says it's a barometer of transitional justice. So this is just a reminder that this is a law that was approved, legislated, not by the USSR, but by its constituent part, the RSFSR, in October of 1991. So this is while the Soviet Union still existed. But it was very much a part of the contest between Yeltsin, who had built his constituency through the Russian Republic, against Gorbachev, and it is part of that moment of I would say almost maximal liberalization and the maximal claim for universalism, universal rights, universal definitions of human rights, and so forth. And it was, in some ways, we could say it's part of Yeltsin's victory over Gorbachev. But when we talk about the transitional justice piece, we're talking about the transition from the Soviet system to the post-Soviet system in the Russian Federation. This law illustrates that because having been written and adopted in the last months of the Soviet era, it was endorsed, confirmed, and has been in place since the transition to the Russian Federation. It was confirmed in 1992. So when we talk about transitional justice, this is a whole field, which I will not give you a lecture on, but these are the kinds of issues that the people who specialize in transitional justice, these are the criteria, these are the benchmarks, and you can see it's a fairly teleological approach. It's supposed to go from abuses of, sort of the universal principles of human rights and so forth, to an idealized form of the rule of law and the recognition of universal human rights, I think you would say. So these pieces are considered to be essential to a successful transitional justice program. This particular law, the law on rehabilitation, contributes most obviously to the historical reckoning and to compensating losses or injuries. The question is, has it contributed to the rule of law? I'm not sure. So as I said, it has two functions. It serves the function of the historical reckoning, and it serves this function of being a social welfare law. I'll leave this up just as a sort of background for people who are curious about it. When I got into being an historian, when I got into the history of how this law came to be, it became more and more fascinating. What can I say? So you're subject to some of the details. In short, what most fascinated me was reading the stenographic records of a commission set up by Gorbachev in October of 1987 within the Politburo, and hearing how the people who were at the very top of the Communist Party were confronting the need to deal with the rehabilitation of victims of Soviet repression, and then to see the process by which they moved themselves at the top of the system to the recognition, and one can almost say resignation before the reality that they were going to have to issue a law to address the outstanding issues related to rehabilitation. So I'll refer to this as LOR, the Law on Rehabilitation, just because it's quicker. And I'll tell you that it remains the primary vehicle in the Russian Federation for addressing the Soviet state's abuses of Russian citizens. It includes a preamble stating its premises, followed by articles spelling out the criteria for designation as a victim of repression, the forms of compensation those people who achieve that status receive, and then procedures for receiving the status of rehabilitated victim eligible for that compensation. Now, there are two echoes of the judicial reform of 1864. I thought we were going to talk a bit about that today, surrounded this law's origins. The first was, there was much talk at this era, those of you who are historians or who lived through it remember, there was a great deal of discussion of a law-governed state as a goal of the late Gorbachev era and then the new Russian Federation. And the other feature, and this was also part of the elite discourse in the 1860s before the judicial reform of 1864. And the other piece that we hear both in 1864 and in this law's formulation and articulation is lawlessness or transparency. So LOR perpetuated the tradition of what we might call the concessionary state. That is that the state, through this law, retained the prerogative to determine who would or would not qualify for the status of rehabilitated. So rehabilitation was thus contingent upon the state's actions and decisions. In this, it's very much a paternalistic and consistent approach, consistent both with the Soviet practices of rehabilitation and with the notion of the imperial state, the benevolence of the tsar, and so forth. So we see that continuity in the way that the people who wrote this law conceptualized it. But victims advocates in Russia criticized precisely this aspect of the law. That is, that the state retained the prerogative to decide who was a victim and who was not a victim. And I will agree with them that this mechanism in this law did rob other entities of the agency that they might have had to define victims and to require benefits as compensation for past harm. Yet I argue that the key articles in the law have, until now, wrested the control over information that was so characteristic of the Soviet system. And that I argue further that this law has stood between citizen and state. As citizens and non-governmental organizations, most importantly Memorial, have staked a claim to formally top secret information. Furthermore, LOR, by being a product of Gorbachev's glasnost, meant that there was a pickup from even the sort of internal workings of the Politburo Commission, through the media, through the press, through the formation of Memorial, ultimately into the two Supreme Soviets of the USSR and RSFSR, that lawlessness forced the hand open for gaining access to the records of these people's repression. And in that way, LOR has permitted the creation of non-state archives which hold these documents. And thank heavens, many of them, through digitization, are beyond the reach of the Russian state, as the Russian state moves in to reestablish control over history and reestablish control over information. And that's in part what this the situation with Memorial this week is. It's significant to that extent. So I would say that LOR contributed to the consolidation of legal consciousness and rights consciousness in post-Soviet Russia among the millions of citizens who have used it to pursue rehabilitation and to receive the accompanying benefits. So again, we have the same, exactly the same kinds of things that we heard in Aaron's paper. They know what their rights are, and they use the courts, and they use the system to pursue the benefits which have been promised to them. So just to give you a sense of the scope of the law's impact, in the first 20 years, LOR has guided the rehabilitation applications or administrative decision for roughly 6 million citizens. And it has resulted in the rehabilitation of some 4 million of those cases. LOR has also generated dozens of cases before the Supreme Court and the Constitutional Court. Furthermore, throughout post-Soviet Russia, staff members in social welfare departments at the provincial and municipal levels oversee the distribution of the law's benefits to those who have been rehabilitated, and as such, they have to explain the law, use the law, know the details of the law, and so forth. Finally, the government of the Russian Federation had in its first 20 years, so 1991 to 2011, amended the law 16 times. However happy that seems, since 2004, the Russian federal government has retreated from the commitments it assumed to victims of the Soviet past through this law. But to repeat, and this has so much to do with legality versus justice, law, with a capital L, and laws have remained the vehicle for the state's retreat from the commitments it made in 1991. The meaning of the law with the capital L, or Pravda, I think some people would say, as embodied in this one law, since 2004, has shifted from what it was at that point in 1991, a means to address the needs of a subset of Russian citizens. Okay, it was directed at the citizens. It was a citizen-focused law. It has shifted now to being a means to address, to protect the financial and political interests of the Russian state. So that's happened at the last day. Interestingly, the Russian citizens who are most affected by that shift have continued to use legal remedies to try to regain what the 1991 version of the law promised. But given their small and shrinking numbers and their very advanced age, it's unclear whether their legal activism indicates any significance for LOR's legacy for resetting the equation between state prerogatives and citizens' rights. So I will just say a little bit in shorthand about the law's efficacy in historical reckoning. The most important artifact, material embodiment of that historical reckoning is the preamble itself. And if you want details about the long struggle, it took basically 4 years of debates inside the Politburo, in society, among advocates for victims, in the Supreme Soviets of the two, the USSR and RSFSR, to come up with this preamble. And it is a very broad statement of condemnation of the abuses of the Soviet past. It is a condemnation in several ways, not the least of which is that it covers the entire period of the Soviet era from the date of the Great October Revolution, of course in November, up to the date that the law was to go into force. But it's also very broad because it incorporates these promises of universal legality and human rights. So it's an embodiment of that high point in universalism. And it also lists how millions of people in the various forms of repression. And then finally, in its third part, it is this promissory note that the state will do what it can to provide compensation for material and moral harm at the level that the state can achieve at the present time. Okay? And that actually is the product, that was the product of so many meetings on, well, how much can we actually do? And not so much. So the preamble is the greatest material embodiment. But I would argue that the historical reckoning that this law permitted is most embodied in private moments when relatives of victims of Soviet political repression or survivors themselves used the law's permission, the license that it gives in Article 11, for them to see the case files of all closed cases. So once rehabilitation had been granted, a survivor or a survivor's relative could go in and see the entire case file. And furthermore, they were permitted to take out of the case file personal effects that had been put in the case file, manuscripts, photographs, not the procedural documents, but initially through LOR in 1991, they were able to bring these pieces, these physical embodiments of their past out of the archives and take them home. So that, I think, it was a hard-fought battle. I will just say it was a hard-fought battle within the Politburo, and I have to share my favorite moment. They had lots of discussion of this, 1987, 1988, how hazardous it is, they must not allow anyone to see these documents, there must be no leaks, and so forth. And at a May 1990 meeting, then chairman of the KGB, Khrushchev, breaks this very orderly, disciplined protocol of the meeting to say, excuse me, comrades, may I interrupt? I'd like to bring a point to the table that's not on the agenda. And he says the following: recently, this is the head of KGB, recently I had a meeting with representatives of the Special Services of Spain. I was interested in how they'd managed the issue of Franco in Spain. After all, when he was in power, hundreds of thousands were hanged and shot. He said, we thought about this and we decided to draw a line under it, not to rummage around in either one side or the other. And moreover, we put up a monument to both the one side and the other. And now we have no questions of any kind. And Khrushchev then says, in my opinion, we really do need to issue a decree, draw the line, and move on. So the fact that they, through this access to top secret documents, citizens, the 6 million, had access to the 4 million whose cases were closed favorably, could get these materials was all important. It fundamentally, from my interviews with them, it fundamentally changed their worldview, their understanding of the state, the understanding of the past, and the understanding of rights and the relationship between the citizen and the state. Equally important, Memorial recognized the opportunity that they could then have to request that any of those applicants who got those materials would give them copies so that they could set up their archives, which now exist in digitized form online. So, just to give you another sort of piece. So Memorial becomes critical to the story. They were critical from 1988 forward. As early as 1989, members of the Politburo Commission are coming in to talk to each other and saying, we're getting all these letters from Memorial and they're just impudent. You know, they're not supplicants, they're not being adequately deferential to us. And indeed, once the law was in place, Memorial took it upon themselves to help citizens write demands to the state, to give them the certificate of rehabilitation and to grant them the access to documents and to send them documents A, B, C, and D. No please, no thank you. It was simply saying, according to this law, you must send this to me, send it to me. And what's so striking is that if you go to the archives and you see the letters that those who do not have Memorial's assistance, the kinds of letters they write, they're the absolutely characteristic supplicant's letter to the tsar or to the district official and so forth. And it's basically saying, please help me, I'm worthy, my father fought in the war. And we were members of the Communist Party. So this whole exposure of the inner workings of the Soviet system by seeing the documents was a major step in the historical reckoning. And and it has made possible a multiplier effect, I would say, of the establishment of people's memorials to the victims of Soviet repression throughout Russia at the sites of mass burials in major terror operations. So this is in Lvashova outside of St. Petersburg, and you'll notice that what you have here is a wooded forest, and if you walk through this forest, you would see that you're walking over the uneven ground of the roughly 20,000 corpses that have been thrown into this forest. But because this young man's relatives were able to get access to the files after he was rehabilitated, when they put up his idiosyncratic memorial, it's a little tutorial on Soviet repression because it has a photograph, it says the day he was born, the day he was arrested, the day he was convicted, the day he was shot, and then the day he was rehabilitated. So that such scenes as this exist throughout Russian space. Here we have, a year ago exactly today, I was at Lvashova with this group of high school seniors who were being taken by their history teachers on a tour of sites of suffering in St. Petersburg in the 20th century. You can see a few of them had flowers in their hands, and when they went around and sort of quietly put these flowers on all of the graves. So you have, the story is still there as long as these parks are still open, as long as the memorial can continue to hold its commemorative events and so forth. But what I find equally interesting is that you have these modest individual monuments, but the government of Ukraine put this one up. Okay. And to the Ukrainian victims of the mass operations in St. Petersburg in 37-38. This is a reminder that these pieces that came through the law and rehabilitation, these pieces of history that have surfaced, it will be very difficult to erase them. And this is just another one further north in Cutlass, and you can see the same thing, the uneven graves, the mass graves. And here it's important that the Polish government has been quite active in setting up memorials to the Polish victims of the forced deportations that passed through Cutlass, and many of the big bodies in the ground are Polish. So, memorial also helps local applicants. Remarkably, in a town like Vologda, there are still applicants for rehabilitation. It really astonishes me. They move into town, they come in from some remote area, someone tells them, you know, you could get a certificate of rehabilitation, and it falls to the local social welfare office to explain to them, what LOR is, what the benefits are, and so forth. So that the process of learning about the abuses continues. And that would be a happy story if they weren't threatening now to shut down Memorial. We can talk about that in a moment. Okay. So let me just say briefly about the 2004 law, the Retreat on Social Welfare Benefits. And I'll say that in 2004, Putin was trying to achieve something that Yeltsin himself had tried to do, which was to rationalize and monetize social welfare benefits as part of a transformation from the Soviet economy to the post-Soviet economy. And it was also part of his federalism that he was offloading some of these expenses to the regions. And one of the things that was interesting about this law was that in addition to monetizing all sorts of benefits in kind, just those ones familiar to all of us who ride the subway. There's one to the right. This is the little office at any metro station where you go in and you turn in your benefits card and they give you cheaper tickets. So that's called the looking immediately. In trying to monetize this, the state had to decide out of the welter of benefits that were the product of the Soviet social welfare state, which ones would the federal government administer and which ones would the regions administer. And much to the insult of the victims of political repression, they were offloaded onto the local illegality of local administration, whereas the victims of World War II beneficiaries were still to be paid for by the federal government. However, one would be hard-pressed to argue that the amendments made to the law, either the 50 leading up to 2004 or this monetization law, that these amendments, which activists and survivors find galling, have been a setback for the development of legal consciousness or rights consciousness. I'm not sure that they have been. In fact, the protests mounted by these communities upon the passage and implementation of the 2004 law suggest that the law on rehabilitation emboldened them in their claims on the Russian state. They protested in street protests, they undertook major letter writing campaigns, and they had multiple lawsuits that have risen to the level of the Constitutional Court. I guess I will say one last thing about that. When talking to people at the Constitutional Court about this law's record in the last decade at the Constitutional Court, they stress the fact that they have allowed a disproportionate number of these cases to rise to the level of a reading because they want to show the respect to the victims of Soviet political repression and to reassure them that the law is something that they can use. However, even though the Constitutional Court has usually ruled in favor of the plaintiffs, none of their rulings have been enforced. In correspondence with Memorial about the fact that the Constitutional Court rulings in favor of plaintiffs objecting to reductions in their rights, Chief Justice Zorkin has written, quote, LOR rulings are by far not the only Constitutional Court rulings not to have been enforced. So I guess I will just say one last thing that links up with Tatiana's talk. The Constitutional Court defends the Constitution. The Constitution of 1993 is also part of the high point of universalism and the promise of being part of the global community of human rights and a higher sense of justice and the law. The fact that there is no enforcement, even when the court rules that according to the Constitution, rights are violated and so forth, has led one of Tatiana's colleagues to write an article this week saying this is the problem. We cannot claim sovereignty in the law at the expense of justice in the Constitutional Court. So, and in particular, he wrote this about the threat now to close Memorial because of the technicality in organizational structure, which people see as a violation of justice and human rights as promised in the Constitution, but which is absolutely legal to do according to the technicality of how an organization should be structured. So there we are, very equivocal. Thank you.
I want to just give everybody a chance to take a coffee, drink of water, use facilities, whatever, but I want to start right again in really 5 minutes, so only 5-minute breaks, so we get plenty of time for discussion. Some mentioned to me in break, we've noticed that we haven't said much about the classic moment of Russian legal history, which is usually a discussion of reforms of 1864. Here we are, 150 years later. That's the moment of time that we're in effect remembering. But we're not talking about 1864 because in so many ways shaped the historiography and the political discussion of the law, whether it was a success or not, whether it was heroic or not, and the discussion of its defining Russian liberalism versus autocracy. Those are questions that we've actually either evaded or just tried not to let determine the way we look at Russian law. And so in that sense, 1864 has been seen here as a moment of legal reform and reconstruction, among other, in a line of legal reforms and reconstructions. So, we will now go to our commentators, and we're really privileged to have two wonderful commentators here today who read all these papers, and in many cases read much longer papers than you just heard. So let me introduce first Daniel Borisova, who is the Charles Seligson Professor of Law at NYU Law School, and his research has focused on empire, territorial expansion, migration, and their relationship to constitutional law in the United States and Great Britain too. So you will want to read his book, which is called The Constituting Empire, New York and the Transformation of Constitutionalism in the Atlantic World, 1664 to 1830. So we're delighted to have Dan, who's a leading figure in legal history, and with a specialization in the Atlantic for another perspective on Russian law.
Sure. It's a real pleasure to be here. And true story, as I was going up to get another bottle of water, an audience member asked me, am I fluent in Russian? And I said, not at all. I know practically nothing about Russia, actually. And she said, what are you doing at the table? So this is a great question. And taking a pro seminar in Russian legal history, and I've learned a ton. And though actually there have been wonderful similarities and juxtapositions, because I have studied two empires on the other side of Western Europe, both in the both actually developing sort of Europe, but not in it, and there are wonderful similarities in especially the development of early American and post-revolutionary American jurisprudence. And I thought I would just mention three themes at a pretty high level of generality that we can either talk about at some point, or put away and talk about the really interesting nitty-gritty. One is the relationship, and this is, I think, I see these themes working through each of the papers in different ways. One is the relationship of the Russian and then Soviet legal systems to Western European legal traditions, influence, models, rejections or deliberate oppositions. The second theme is the problem of law in revolution, both the revolution 100 years ago and the one 25 years ago, and the degree to which there are continuities and the ways in which there are changes. And then the third, which may be just something that interests me as someone who teaches mostly in a law school, is what historians bring to the study of the rule of law and what we can add to discussions and understandings of the rule of law as a historical phenomenon. And I think this one is particularly difficult because we all look at it through bifocals. And one is we're members of the 21st century and we have ideas about what the rule of law is, regularity and what we think falls from that, and transparency and decision-making, and maybe substantive commitments as well, freedom or democracy. But then we're looking back at the past of people who actually maybe they use the same language or they use synonyms, but they seem to be meaning different things, and how they use these resources that create a kind of illusion of continuity and fellowship across time. And it's always interesting to wonder, how, when you're studying these historical actors, how are they using these resources in a particular situation, and what are we doing when we bring up, what wonderful little anecdotes about the rule of law today. I'll try to talk a little more about that. But I thought I'd also try to go through these themes by asking questions of each of the commentators, and it's somewhat arbitrary whether I fit them under one theme or another, but starting with in order of presentation. So Sergei's paper, I really like this as a law professor, looking at jurisdiction in the books, as it were, and how it works out in practice. Estates in the book actually much more interesting and jumbled in practice. The process, inquisitorial, maybe in criminal law, but in civil law it's actually much more adversarial. And then proof. The reputation of formal proof turns out not to be so important in the way that the courts operated in practice. So my question is this: did the judges or the advocates, the parties who seem to play such a big role in civil debt litigation in particular, did they examine how other legal systems dealt with the problem of authenticating credit instruments? Now, you mentioned the work, for example, of Jennifer McNugan and others who have looked at handwriting and changing legal opinions or legal decisions about how you verify handwritten signatures over time. Did your advocates, was it just like simultaneous development next door in Russia and Germany and across the Channel or the Atlantic, was because they're experiencing similar technologies at the same time, the reliance on signatures and the circulation in impersonal networks of credit instruments, or are they sharing some learning about this and what's the best way to authenticate the signatures? And I ask this because this might shed some light on the relationship of what's going on in evidence law in pre-reform Russia to what's going on at exactly the same time in other jurisdictions, whether there's some influence one way or the other. Aaron's really interesting paper on the I took it as the relative continuity in these local courts, and it brought to mind work by one of my colleagues, Bill Nelson, who's been writing about community studies and what goes on in local courts. And many of the same things went on in 20th century Russia and the Soviet Union, as went on in 17th century Massachusetts. Like that interesting, inheritance disputes and domestic law or domestic relations, that used to be called family law now. But here I had a couple of questions about the changes. So the liberalization of divorce law, where was the energy for this coming from? From the parties themselves, like part of the revolution is the liberalization of divorce, or should be the liberalization of divorce law, or coming from in some statutory form, or worked out by these judges and the enduring clerks through some kind of what we would call common law or decisional jurisprudence. Like, where's the law coming from? So relatively from the bottom up, from the top down, some negotiation between top and bottom. And I also wanted to ask about what kinds of disputes were not in the new people's courts that used to be in the old township courts. So you have, for example, this wonderful case of the Petrov brothers. Not one he mentioned, but it's really interesting. 3 brothers. One of them dies, sadly. The other 2 brothers fight over the inheritance. But correct me if I'm getting this wrong. One already has a lot of property, he's rich. The other one, I guess, has less, he doesn't have much. And the poor brother thinks that he ought to get more of the inheritance from the deceased brother. And they go to court about this, and the court decides, we've abolished inheritance in the Soviet Republic here, and we're going to expropriate this property. Now that seems to me would be a pretty good signal to the community. Don't take inheritance disputes to this court anymore. Let's work them out elsewhere. That doesn't mean that brothers and siblings and children are not going to fight over inheritance. They're not going to do it in these courts. So, you know, it's sort of the subject matter jurisdiction somehow gets worked out, probably through literally trial error. But I'm just curious how this works out, and again, is it a statute or decisional law or some sense of the people deciding, you know, more liberalization of divorce, less inheritance. Now, I thought, you know, Tatiana's paper is closest in some ways to the work that I do about one of my projects on elite jurists in the early republic and their sources of law and their relationship to European sources and authorities. And what I wanted to ask here is, what were the stakes of the institutionalization of law through these literary projects, the digest, the codification? Like, who was gaining what? So I understood your anecdote that there's something enduring about the rule of law. This is what I was mentioning at the outset. We all understand the idea. We're touched by this idea that there's an enduring rule of law, but we're also, shouldn't we think about the interests of the jurists who push the rule of law? Like, what else do they have at stake in addition to, though not to diminish, their identity as transnational or cosmopolitan or transhistorical figures in an ongoing legal project? I just was wondering whether, you know, the people who were setting up this bureaucracy with its relative autonomy wanted more from, you know, what were they getting out of it? So what were the stakes for them? Besides, what I'm worried about is that we might end up writing a kind of Whiggish but then catastrophic history about the rule of law. Like, it had its moment and then was shut down, and maybe it'll rise again, as opposed to a more textured story about what these advocates for the rule of law in certain times and places were actually trying to accomplish, and the degree to which, again, they might be copying cosmopolitan sources for all kinds of interests that don't have to be like truly material, but identitarian or other. And then finally, with Cathy's really interesting paper, I had a couple of questions about whether you thought that the rehabilitation process, you brought this out in your talk even more than the paper, was indigenous to the Russian tradition, or was part of an international development at about the same time, where we start to see lots of truth and reconciliation commissions. Because, you know, you use the nice example of Spain, but I was thinking of 1661 in England. Parliament passed the Statute of Oblivion, where no one was even supposed to talk about the interregnum. Like, it's a big immunity statute for everyone on both sides. It's over. The king is back. We're not even going to talk about it. It's all in oblivion. And this is actually a rather dramatic example of a series of oblivion statutes and after-the-fact immunity statutes that passed in the Anglo-American tradition. These truth and reconciliation proceedings are very different. The whole point is to explore them. And I'm just wondering whether they have roots in this Tsarist and Soviet tradition of rehabilitation, or whether they actually should be seen as coming out of some sort of international dialogue at the time, look at precedents from Argentina, what's happening at about the same time in South Africa, etc. But I've gotten the signal to wrap it up.
Okay.
Yeah. So I think since these dance questions are quite specific, we're going to get, we'll give each panelist just a moment, short answer to these questions, and then we'll go to the next commentary, and then we'll open up to the audience. So you want to go first?
Sure. I think that that's a great question. Basically, the answer to that is that when I was doing research for this project originally, and it was really difficult to access those imperial era legal, even just the basic statutes. But now, since 2008, they became available online, so I can actually go and trace basically the legislative history, what we would call, of every one of those rules. But as a sort of a general answer, the Russians were very much conscious of sort of what everybody else was doing. And one example I have is they sent a doctor, a prison doctor, who was on a nice vacation in Paris, to go and tour debtors' prisons in Paris and sort of write a nice big report, which he did. I assume he was doing other things as well in Paris, but yeah, the Russians were sort of following sort of the latest trends.
Yeah, thank you very much. These are the three general points. Great. The thing about the liberalization of divorce is actually statutory. What is surprising is, I think, how quickly the peasants clamped onto it in just waves. Shocking. Where you see kind of more of a give and take is with alimony in the 1920s, of being able to use alimony, of using the laws and using kind of spaces within the law to get more by women. The disputes that are not in the court, that's a great question. Inheritance changes into property disputes, even though they ban inheritance, but then inheritance kind of comes back in several other vestiges. They also play off other legal institutions. Land committees, or actually land commissions, are big ones where if they're not going to get a good resolution in the People's Court, they go to the land committees, and actually, so they're able to go back and forth into other social welfare efforts. So yeah, peasants quickly learned how to use the system.
Thank you. As for the interests in the rule of law, there was one very strong, the strongest probably in Russia, power, political power, and that raised quite early. That was already in the early 50s, when in journals there was some critique on the procedures practiced in courts, which are actually against the statutory law. And that critique was immediately noticed by the government, and there were special prohibitions of any discussion on law in journals, in literary reviews. That was on the very eve of reform. It's very surprising. That was 1856, just 8 years before reform. So, and that's actually a problem of rule of law in Russia, because it became a political flag, so to say, that let us rule, because we know from our professional expertise, we legal community, we professors of law, we know what is rule of law about. Like in Russian parliament, they could tell, we do not have this right in the statute, but we have this right because we are parliament. So you see the stake here, that's the political power. That's it. Thank you.
More insular than comparative. And it's important for us to go back to the moment. 1987, lawlessness has just taken hold. It's still very much a closed society. Looking back on these processes, even the leaders of Memorial talk about how little we knew. The linkages would have been through the international human rights movement, and indeed Kovalyov, who was leading the Legislative Commission within the Committee on Human Rights in the RSFSR Supreme Soviet with this law. He was, of course, going to the international human rights movement, but not in the transitional justice movement. They were very much engaged in politics of the possible. And they were in a polity that was falling apart. It was such a contingent moment. And they were very much aware of the precedent had been set by the rehabilitations of the 1950s that they could draw on that tradition and build on it. And they all thought that this was itself, this law was a first step. They thought it would just be the first step and that many others would follow in the course that they had. Is that, yeah.
Okay, well, we have one commentator, that's Richard Wortman, and in this audience he needs no introduction, but I'm going to do it anyway. Short. Richard Wortman is the James Bryce Professor Emeritus of European Legal History at our neighboring institution, Columbia University. And he is the author of many, many influential monographs. But the one, I'm only going to mention one here, and that's one of his early monographs. And it's called The Construction of a Russian Legal Consciousness, published in 1976. So this is a truly pioneering, fabulously innovative book, a great read, one of the very first studies to explore what we're talking about today, which is a legal trajectory for Russia and how Russia's elites came to remake the law in the 1860s. So there have been many wonderful books since then, but I want to take this opportunity to thank you, Dick, for setting us out on this journey. Thank you very much.
Thank you, and I'm very impressed by all the papers and the, let's say, it wasn't construction, development of Russian. You were reading the Russian.
This is true.
And I'm very much, and when, since it's nearly 40 years ago that it came out, and when it came out, it was promptly in Russia put into the special fund, along with politically dangerous works and pornography for many years. And so now we have Tatiana's work and all the others. I've been very impressed by the papers. I'll start off with the two, brevity, the two ones on process, based on court records, and I found both of them very well done, following very much, to return the compliment, the approach of Jane Burbank in looking at actual cases rather than generalizing from the literary sources. With Sergei, I will begin by making the full admission of full disclosure that I'm Sergei's dissertation advisor, and so he's heard a lot of criticisms from me and a lot of support. But it was interesting. I mean, what he does is very much to overthrow the standard notion of court reform of 1864 as a major change, as everything before was awful, and he cites all sorts of books that characterize the old courts as awful, mercifully leaving my name out. I thought, it has much more resonance than just the court reform. He's showing that there is not only a culture of debt, but a legal culture before 1864, which will then go into the later developments in many ways based upon some earlier practices. And I think this is extremely important. I just have two brief questions on this. And one is the one that I raised before with Sergei, and that is the representativeness of the dead courts as a basis for such sweeping and meaningful conclusions. And secondly, the question of why everyone from all political viewpoints, conservatives, radicals, officials, thought the old courts were awful. And what needs did the system not answer? And which were to, say something nice about the court reform of 1864 on its anniversary. I'll leave it to you. Now, Aaron Retish's pursues a similar approach, also taking the argument of continuity, though lacing it with Soviet changes, and he is a real tour de force of archival work and going and getting, like Sergei's, the materials to see what exactly is happening, rather than blanket statements, dismissing the Soviet's own, what he calls theatrical rape of the past, with evidence of things that are going on, the Commissariat of Justice, introducing the existing courts as a means of establishing authority, and the regime backing away, and yet the regime also shows how the Soviet concepts are being introduced, more or less successfully, particularly in regard to family law and inheritance laws. This I find, as I say, is eye-opening. And my only objections are the occasional interpretive leaps, where Aaron gets carried away and outstrips the evidence. So let me just give you a few examples. I don't think I'll make you blush, but not if you blush. On page 9, you said the judicial system worked remarkably well from the beginning, considering the circumstances. He mentions the Bol's local courts organizing Congress, and then the rest of the paragraph reads like this: elsewhere, though, courts were riddled with problems. The chaotic developments of laws and instructions from the center that guided court rulings made it nearly impossible to run a court smoothly. Many court personnel did not have the legal experience to manage court functions, despite slogans that the Soviet regime favored proletarian revolutionary consciousness over statute law. In reality, judges' inexperience and ignorance of the written law drove narco-used officials at the provincial and national level crazy. A typical complaint came from the Vatyak, the autonomous republic in 1921, quote, most people, quote, judges are completely inexperienced, weak, and are unfamiliar with judicial proceedings, and some of them are barely literate. So in some areas, judges do not know the elementary procedures of law. Now, how this comports with your general conclusions, I don't know. Then he says on page 5, the People's Court, after all of this, were popular and widely used by Soviet citizens, and it maintained a rational legal order through the chaos of civil law. I think you need to show this, and then his last line is, if peasants were drawn into the Soviet legal matrix, they did so voluntarily. They held a deep understanding of legality and drew on it when negotiating with the state and arguing with their family and neighbors. So so I want to see more evidence of peasants with a deep understanding of legal reality. Okay, now, Tatiana and Professor Borisova's paper presents different problems because it is a long 28-page, single-spaced overview of the system, and in my 3 1/3 minutes, it would be hard to do it justice. And what she is an ambitious effort which reveals her intense involvement with and command of the subject. She focuses very well on what she calls legality with adjectives. That she comes out with, meaning the ambiguous, elusive, frustrating, in its uncertainty role of legality in Russia's institutional development. And she pursues this and indicates on how legislation was published, why particularly legal procedures for publication were chosen, and most importantly, what these procedures tell us about the law in Russia. Now, the most important part of what she shows is the work of technical improvement, the technical which she spoke about, Antonov, the publication in terms of developing a concept of the law that goes through this period and taking it seriously and making it a major event. At the same time, it shows the law's ambiguous character, acting as an ideal that is realized. And the tragedy is in the law's piecemeal success and its decline to become lesser the codification, the education, the development of an elite in the government, and the problem becomes one of autocratic legality, some legalness, while the digest represents what she calls a benchmark of the emergence of a Russian legal traditions. She mentions the conflict with these traditions. And here I quote: "The idea of the authority of the law was rejected as irrelevant to an unrestricted autocracy," showing the conflict with the autocracy. In other words, rational reforms conflicted with the traditional norms that animated the system. And she writes, Western ideas of law were used to educate Russian legal specialists, were used by Russian legal specialists, collided with the reality of state domination. Well, my criticism with her here is the extent to which this takes place and its very nature. She, at the beginning, towards the beginning, divides the specialists into critical types, like myself, positivists who were in the 19th century, and then the angelic, heroic minions of the functionalists, and which enjoy her allegiance to a great deal. But she doesn't really seem to belong to the functionalists, since her whole discourse is one of criticism that's very close, in fact, to my own views. And here I might point out that she misreads misreads a statement I made in the introduction to the Russian edition, where I spoke about cultural fictions, in which she said that I am revising my views, more or less throwing out all influence of the law, and claiming that it's basically inoperative. And the law I wrote, what I wrote is, was a cultural fiction within the symbolic sphere of the monarchy. The realization of the law was not the basic problem for the emperor and the high bureaucracy, which is exactly what you say in the So if you're a functionalist, I'm a functionalist. And here I'm not trying to relegate you to one school or another, but to question the sharp and simplified opposition between the critical and the functional. The differences are overdrawn, and we are engaged in a single project. Our territories are not alien from another. Finally, I'd like to emphasize the importance of the political context. The autocracy's antagonism to legal limitation was not limited to a fear of encroachment on its prerogatives. The legal sphere is only one part of the monarchy, as I tried to show in my other book. The monarchy inhabited not only the legal instrumental, but the symbolic representational sphere of Russian government that set the monarchy not only above but apart from state institutions. And on this, the law could not encroach. And here, I think this comes out most vividly in the most important work on the functioning and practice of Russian autocracy, and that's Rimnyov's book, Самодержавное правительство, autocratic government, and autocratic government, he says, is an oxymoron, that the autocratic government did everything to prevent legality. And if you I'm sure you've read the book, and it's a vivid description on how any kind of regularity at all was rejected by the autocracy. So here I'd say that the law is only one attribute contributing to the supremacy of the Russian ruler, and the symbolic one in Russia, and whether this is traditional or simply within the functioning of the Russian state is another thing. And here I would see our present ruler now as who flies along with storks in the atmosphere and shows his muscles, and recently was depicted, I don't know if any of you saw that, as perpetrating the 7 labors of Hercules in a series of patterns. So I mean, here he is more or less restarting. The law is something trivial, you know. I mean, so I think that's now the other point. I very much admire Cathy's work on this. I found the whole thing gripping and moving because I, of course, experienced the heady feeling of the 1990s and suffered from, in many ways, from its passing. And the 2 working papers she submitted have all sorts of examples of really very touching and moving personal responses to this whole thing. It brings back the ambiguous historical role of the law in Russia, and it reminds one that we went through something that we didn't realize it at the time. It was like so many of the other reform periods. You know, we look back, this is 1860s again, and we forgot was the 1870s and the 1880s, and now we're experiencing the 1870s and the 1880s, and the drama, in the heroic struggle, and the sharp decline that Cathy talked about, this excruciating dialectic between a hope for truth and justice and the ruthless despotism and staggering inhumanity that comes about, and the cemetery and the pictures of the cemetery, and all of this coming up just as, you know, this disclosure about the cemetery, mass cemetery in East Ukraine that's occurring. All of this I see in a global perspective as one of the grand dysfunctionalities of the modern 21st century world that we have the unfortunate necessity to confront. The second point I want to make is more prosaic but equally important, and that is the coinciding of the quest for justice with the introduction with the measure of pluralism, which your paper shows very well. I mean, all of these groups coming into existence the moment that law becomes a major factor, where law really is a factor. So people come into groups, particularly Memorial, but others to defend law. And of course, for an autocratic regime, there's nothing so threatening as pluralism. And that's part of the legal trajectories is the permission of a little bit of pluralism, and then the realization is you can't have a little bit of pluralism. It comes when there's an existence of independent groups willing, and particularly the distinction between grace and dignity. This brings it out so forcefully, and that now is going to be erased. We also have to realize one of the reasons for this reversal. If you experience the 1990s, we also recall it was a time of terrible economic stress, administrative disorder, widespread crime, wages weren't paid, and the society was in complete backbed. So it's not clear that a pluralistic society can develop in Russia. And those of us who harbor these teleological hopes that history is going to be on our side, I think it's all a very sobering experience.
Yeah.
Should we go to general questions? Yeah. So we have the audience has been extremely patient.
Aren't they going to answer my question?
No, let's put it this way. If as part of, let's gather questions from the audience and then responses to the audience and to you.
Okay.
Yeah. Yanni, now.
I wanted to thank everybody, and Jane in particular, for a wonderful session. As for Richard, has been he's taught me for 30 years. He's never said anything that is impressive, or gripping, or emotional. So you should feel privileged.
Is that a critique of my teaching?
But seriously, I think this is all a tribute to 45 years of amazing original scholarship, and we should all be grateful. The question I had for you actually goes back to something that was raised by both of the commentators, which I'd like to connect. One of them is that the comment that we use bifocals when we look at the information, which I thought was astute, which really implies that we ourselves inhabit a certain universe and we have certain standards, and we necessarily project them backwards. And up to a point, I think that's fine. As for our subjects, though, they're also in motion. And in terms of what was so strikingly archaic about the pre-reform system, and then also what was so strikingly archaic about the late imperial system and the late Soviet system and the current system, all of these things imply to me, at least, that we have notions of justice that are in motion as well. I'm wondering if any of you, and this is more sort of a comment, but if you have an immediate answer, that would be nice too, which is that, to loosen our own understandings of what justice might be, what it's meant to achieve, how we define it, And I think one of the takeaways from all of this is that the rule of law is something that we might like, but is not necessarily operative. And so if that's not operative, then what is? And in connection with that, there's something that a French philosopher wrote, and I read recently, which is that the law is something that can prescribe, and it can forbid, and the law is something that it can also give us opportunities to seize upon, to use them to our own interests, and then we measure how that law succeeded by learning of the standard. But in another sense, the law is also participatory and formative, and it's formative of ourselves. And the point that this scholar was making was that the law is something that it's an invitation to practice it and live it and to learn from it at the same time. And I'm wondering if in each of these historical circumstances, contexts, whether it would be useful also to look at the law as an educational didactic tool, which is how it was meant. And certainly in Soviet times, but I don't think it's only Soviet times. I mean, in Argon's case, citizenship is written all over, obviously, but I think the same might apply elsewhere. So even looking at the most recent cases in Memorial and looking at the human rights violations, I mean, when someone is told that you can use these laws to explore rehabilitation, exoneration, and whatnot, this is also an educational process, I think.
Let's have another comment, question, and then we'll give it. Yes.
Question for Professor Borisova. If I understood you correctly, the emphasis is more on the adjective than the legality, or the adjective is more important than the legality, and I think you used the word embodiments of legality, where maybe it's events or reforms or institutions are also more about the adjective than the legality. Could you comment on what's happening now, the unification of the Supreme Courts and its transfer to St. Petersburg with a very grandiose, complex and beautiful and thought through? Is this more about sovereignty than legality, and especially the move away from the center of power? Is this a seeming strengthening, but a real weakening of the institution of the courts, as if we were to move our Supreme Court to maybe Philadelphia?
Let's have one more question, and then we'll go have a round of answers. Susan.
Well, I was going to ask Cathy, if Professor Frierson, sorry, if maybe the people that put together the law in 1991 studied what happened not in Spain but in Germany. Did they study it? Did they get some kind of, and as a subtext, I mean, you talked about economic rewards or some kind of reparation, what the Germans call reparation. What kinds of reparation did people get beyond the cheaper transportation cars or whatever? And thank you all, because I think this was a wonderful, wonderful panel. I'd just like to say that it was beautifully orchestrated. Thank you, Jane.
Well, let's have a round voluntary of responses to any of the commentaries and questions, and then we'll have another round of questions. Okay, so who would like to start? Sergei?
So, yes, so Professor Workman, great comments and questions as always. And yes, I've heard a couple of them before. But it was a long time ago. And so it was like at least a year ago. So my thinking has really changed since I completed my manuscript since that time. And basically on, enlightened bureaucrats that you write about, I mean, I see them all the time in my court cases, and they do make a great difference. They write better, they express themselves clearly, and I think they really sort of step in, and even, they would not make it to your book because they were too sort of lowly kind of guys, but they do show this sort of new consciousness. And so I think, when they appeared in the 1840s, they do make an impact. Then the question of representativeness, I do write about a credit network that was based in Moscow. And Moscow, Moscow, of course, not all of Russia, but in terms of credit, it was a powerhouse, even sort of probably more so than today. And paradoxically, while reading all newspapers, I discovered why I think that was the case. Railroads. So until there were railroads, Moscow merchants sort of had this like really disproportionate control over stuff that, goods and money that were in and out. And so it's, so yes, it was not sort of the only thing that was happening, but it was really kind of disproportionate. And St. Petersburg mostly dealt with foreign imports, and Odessa, of course, also did as well. And I'd love to go to Odessa. I don't think my family will let me go on the research there now, but I mean, I would really like to sort of complement that, supplement that. So in terms of debt being representative, I mean, in terms of anything that had to do with money, I think you kind of run into issues of debt. But of course there was another legal culture, sort of low-level, drunks and thieves and vagrants, and by far, sort of the bulk of the court's case law was concerned with those kind of people. And yeah, I mean, I'm talking about sort of upper middle strata of the legal culture, so that's true. And then finally, why everybody hated these courts. Well, I mean, we all hate PPOs and medical insurance companies right now. I mean, they're horrible, right? But that doesn't mean that we have no medical care, but there's no medical care in America. And then also, I mean, at least when I was practicing law, I was kind of struck by like people hate lawyers, and people, our clients, tell us that they hate us, and these clients, and I'm talking about big banks, big people, rich people, they have absolutely zero regard for the law. It's like purely instrumental. And so, I mean, I think we just have to compare apples and apples. Much as we're sort of dedicated to the rule of law, we have to be aware that even people around us don't have to share this. And then, yeah, I mean, in terms of say something about good about new courts, I mean, I think they could provide, people with money, they could provide good sort of efficient, quick justice. And so, I mean, I think overall, I do think that would better. I do think that would better, at least for people with money. But I also think that sort of all the courts, they would sort of take longer time, but they still sort of accomplish certain purposes. So if you wanted to sort of win your case quickly, then you go to the new court. If you just wanted to harm somebody, you go to the old court. It's like, people talk about civil law countries, they say, and common law countries. They say if you're innocent, you should be in a common law country. No, rather, if you're guilty, you should be in a common law country. If you're innocent, you should be in a civil law country. It's sort of the same thing here. It depends on like what your objectives are, basically. So that's what we have to compare. So, yeah.
So I'm going to try to answer one of your points. Thank you very much for these pointing out. I'm sure there are several other short tweets that I made that I'm glad you didn't have. We're going to try to bring in one of your points with something that Yanni said, and this is the idea that where I said the judicial courts work well, even though there's where courts were sometimes even in barns with animals. So I wrote that in part because I didn't want to over-romanticize the courts. I wanted to show both the good and the bad, but also part of it was, as Yanni talks about, it's kind of this projecting your own sense of the law or legal culture onto the subject. I was trying to be in discussion with a lot of the literature in the West on the early Soviet courts that is wonderful, but they all take it as this assumption that the courts didn't work well because of what I just said, because the judges aren't educated, etc., and that it's a Soviet administrative system. So thus it couldn't work. And I'm trying to show that in fact, kind of like and also they were also continuing kind of the discourse from the imperial era on the Polish courts, that despite that discourse, that they actually were working well. In fact, they were working better in many cases than they were working in the mid-1930s when they were adhering to the law, but they actually weren't helping the citizens, that citizens were coming to court, and that they were used more for punitive. So that's kind of that's kind of the balance that I was trying to reach. I'll leave it with that.
Thanks a lot. And I'm happy that we are more functionalists. So, more of us here. Well, I see my approach functionalist in the sense that I study the sources of law. And these sources are physically, so to say. I'm interested in how the law became much more accessible after the digest was introduced. Indeed, it was sent out all over the empire. It was accessed by everyone literate. And if people had a need for that, it could be easily found around in any public office. That's very important. And critics of autocratic legality, they were very thankful. They wrote Gladowski, for example. He wrote very positively of Nicholas I, saying that he gave us these pillars of legality, and then we come to Yannis' comment on educational potential of law. The digest educated Russian lawyers because it became a first hornbook of the Russian law. And it made them extremely critical about the Russian law, since they had this Western theory taken from Germany, from France, on the natural rights and the rights of a natural person, what was severely criticized by Russian censors, for example, and the first Russian books on natural law were prohibited just because we do not have any natural people here, natural humans. We have Russian subjects. That was the reason. So that's why law indeed transformed, and that's why these sources, these books, these laws and books are important, and we have to take them into account, although it's very unfashionable these days to study old books. And going to your comment on the question on this movement of Russian highest courts to St. Petersburg. Well, it's interesting that the reaction was very negative within the community of lawyers. Nobody liked that idea at all. And indeed perceived it exactly as you put it, as a rhetorical strengthening of division of powers. Indeed, there is so much power, political power, legislative power, administrative power in Moscow. So it was really advocated as strengthening the division. And everybody was unhappy because there is no real division. So the reaction revealed this sentiment about getting far from the real center of the power and getting the authority of law down. So it's indeed about adjectives, I would read it, and making the adjectives strong than universal standards of rule of law.
Thank you. I wondered if I would come here and wish I'd gone to Columbia. So we'll leave that for the dinner discussion. But I'd like to do it in this order. First, I'll describe the types of reparations, and then that'll lead us through all of the questions, and I'll leave out the German question for now. Very generous reparations or benefits. And indeed, that was part of the 4-year debate. At what levels should these benefits be targeted? Where should they be pegged? And the contest was whether they should be equal to the the participants in World War II, veterans of World War II, the highest level of beneficiaries in the Soviet social welfare system. And the advocates were pressing that, yes, it should be equal. And of course, the Politburo, et cetera, were didn't want to raise it to that level of equality with veterans of World War II. So the battle over history was intense, even in setting reparations. Everything, so one of the nice things, so very generous, and one thing that you notice when you go through this incredible list of benefits is that they were indeed trying to compensate for specific losses. So whereas victims of political repression lost mobility, one of the most prized benefits where all of these was free local transportation and an annual round-trip ticket on a train anywhere in the Russian Federation. And all sorts of other ways to move around. Free cars if you couldn't use public transportation and you had access to a free car. And so it went as from there all the way down to, because so many of these people lost their teeth due to scurvy, they had free dental or reduced rates for false teeth. And it was just really quite remarkable. So of course they laughed now, and there was a monetary, there was a stipend also, which was a part of the politics of the possible. When they were writing, when Kovalyov's committee was writing this, they kept meeting with the people in charge of the state budget and saying, how much money is there? How much is there, do we have in the bank? How much does the government have? They didn't know it was falling, in 2 months. So they had to peg it very modestly, much less than what they would have hoped for, because they, again, only wanted to offer something that would actually be paid. After monetization, all of these benefits, everything from medicine to false teeth to half price on your utilities, first in line for a new apartment, free construction materials in your house, I mean the whole 9 yards. One of my informants, I even hate to use that word, subject, her monthly stipend in the city of Smolensk is $8. Okay, that's what it came down to by November of 2007. So that's what the reduction meant. When it got monetized and they were able to say, well, in Smolensk, it's only worth, if you put the whole package together, $8. So this leads to your question about remember the 1990s. One might ask the question, why on earth would an LOR beneficiary vote for Putin? And that same woman in that same conversation where she was talking about how the local, administrators after 2005 had just robbed them all and reduced them to every kind of humiliation and indignity. She said, our only hope is Putin. As awful as he is less awful than the local satraps. And because of monetization, they can do whatever they want and no one's going to interfere. And that's all the more striking because I will say that in the chaos of the 1990s, in the sort of our starry-eyed 1990s, dewy-eyed, the amendments repeatedly expanded the categories and expanded the benefits, even in the face of all of that economic chaos. So the commitment continued through the economic challenges. Then to turn to Yanni's question, which is of course where Yanni used to be. This was my fondest hope. And I'm hanging on that thread. Will Pomerantz and I are hanging on this thread. And I guess I'd love to hear Tatiana's response. In the face of the reality that constitutional court rulings have not been implemented, and that direct orders to the Duma to correct problems in the 2004 law be corrected in order to ensure that they don't violate the Constitution. Does it matter that the Constitutional Court posts all of its cases online, all of its rulings online? The discourse is out there. And so the educational function, and I think this business of make the law known and having access to the law, even the chair, under the chair, under Medvedev, he ordered that every district local court had to have an online database of the laws which every local citizen could come in and use. So there was still this great push to make the law known in the same way that did. So for me, the filament of hope is that even these unenforced rulings, which continue to cite the Constitution, to cite LOR, they leave it out there. It's still out there as a weapon to be used. And I'll just say very quickly, as a daughter of the Deep South, having lived through the Jim Crow era, We didn't exactly make our promises good very quickly either. And as scholars have turned to look at the affirmative action, civil rights, and so forth as a transitional justice topic, one of the things that they stress is even though the laws weren't enforced, the promises were there, the discourse didn't die. So can we have any hope that the educational function of these laws through the online world matters? I don't know.
Well, I think it's past our time in this room, so we're going to have to close. But I want to thank our panelists for wonderful discussions. And I want to thank all of you. This is a wonderful, it seems to me, sense, at least from this perspective at the head of the table, of a sort of community of people interested in the study of Russia in New York. And so thank you all for coming and being a part of this.